Hello dear friends, welcome back in our YouTube channel Indus Lex. We are discussing salient features of Indian Constitution. This is part 2 of our discussion. In previous lecture, we see the framework, how we can check on the basis which the constitution can be adjudged against another constitution, and in which we touched some key elements like federalism, free and fair election, rule of law, separation of power, and then further we discuss how much it is important that Indian judiciary with judicial review power, and therefore we make a separate discussion on the concept of independent judiciary, separation of power, and power of judicial review. Dear friends, we see that the fundamental rights is given to the every nationals from Article 14 to Article 35. What given in this fundamental rights is something what state cannot infringe by making laws, and how it is going to be checked. It is checked by the independent judiciary. How it works according to the other statutes are interpreted, are drafted. Part 3rd starts from Article 12. As we know that the part 1 of the Constitution deals with union and its territories, and further part 2 deals with the citizenship, which we have already discussed in the part 1 discussion. And then we talk about that several fundamental rights in part 3rd, in part 4 directive principles were given in the Constitution of India. Here in part 3rd, that the word state defined under Article 12 and word law defined under Article 13. And Constitution says that any institution, any organization which come in the definition of state, that the state is defined under Article 12, which come in the definition of the state, cannot make law, and law is defined under Article 13, which abrogate or infringe or abridge any of the fundamental right mentioned from Article 14 to 35, that the word used in the Constitution is in this part. And further, at the time of the commencement, it says that every law, every rule, every regulation is null and void, or it can't be inoperated from the time of the commencement of the Constitution, meaning thereby whatever the law may be in operation, or even the law can't made in the future. So this power is called judicial review, when court check the law on the premise that whether that law is permitted under the Constitution of India, and what is permitted and what is not permitted, at what extent the parliament can make law, what extent the state has rights, what extent the court has judicial power, what extent that the characteristics of Indian nation, that all will be dealt in the Keshwanand Bharti case, that is versus state of Kerala. It is 13 judge bench order which deals with the various fundamental questions such as which one is supreme, that the parliament sovereignty, that the will of the people, or judicial supremacy, where court has to see whether the law which passed by the government is actually a good law, whether there is rule of law, there is no arbitrariness in passing or making of those laws, and that all should be tested. And further, it tested at the foundation of whether it is conformity, it has conformity with the fundamental rights given in part 3rd, whether any provision may abridge the rights of the citizen which is provided under this part. So no law can be passed which abrogate the fundamental rights of the citizen. Due to this problem, or maybe to deal with that when government has to implement some directive principles, that is ban on cow slaughter, maybe for the implementation of DPSP under the Gandhian principle that the slaughtering should be banned of the milch animal. Then it is also related with the business related with the occupation, which is protected under Article 19. So, what will be the line? What would be the power of Parliament to amend the Constitution? Amendment power of the Constitution is not given to the such extent that it violates the basic structure of the Constitution. The very core foundation, which is a key characteristics, otherwise can be altered, and even fundamental rights can be amended. But by making amendment in the Constitution, the only permissible, the extent of amendment permissible in the Constitution only to the extent that it doesn't violate the fundamental rights. Meaning thereby, if there is ordinary law, rules or regulation passed by executive bodies, not by the legislature itself, that can only be tested on the principle of natural justice, and when that is passed by the legislature, it would be tested at whether it has conformity with the part 3rd of the Constitution. If it violates the law mentioned in the Article 14 to Article 35, the court shall declare that part, that law or whole act as court deem fit null and void. And therefore there is necessity to change the Constitution also, to amend the Constitution also, and therefore Article 368 is there. So the question arises, at what extent the Constitution itself can be amended, because till it is there that the no legislature, executive or even judiciary can make law which can abridge the fundamental rights of the citizen. But for the enforcement of DPSP, or for broader perspective, for wider prosperity, if state want to implement some projects, then fundamental right can be curtailed, and it can only be curtailed by making law, and the law adopted by our legislature is by making amendment in the Constitution, and by making first amendment in the Constitution, new set of legal battle is started. Because for in the name of implementation of DPSP, whatever law state makes, if it want to save from judicial scrutiny of judicial review, we can say, put that act or law in 9th schedule, and 9th schedule, after getting in the 9th schedule that action of the executive under that act, if it violates the fundamental rights of the citizen, the writ jurisdiction is not available to him, or that per se in the writ jurisdiction court can't say that the act is violating the fundamental right, therefore that act or that conduct would be ultra virus to the Constitution of India, because it is permissible by the Constitution of India itself. And using this methodology, what legislature done, whatever the act they want to make, they make and put it simply in the 9th schedule and try to save from the judicial review. So the question is very important, that whether the amendment in the Article 368 itself, which provides amending power to the Constitution, even the Constitution can be amended by way of 3 methods: simple majority, 2/3 majority, and sometime involvement of states is there in some cases. But the key provision to amend the Constitution of India is Article 3, and whether an amendment can be done at the extent that even the amendment provision of the Constitution can be amended. Can a legislature by using Article 368 amend the provision itself, and what extent can Article 368 or some amendment power of the Constitution can be permanently be repealed by the using the amending power? Then further question goes on discussing another legal battle relating to the preamble, whether the preamble is a part of the Constitution or not, whether there can be amendment can be permissible in the preamble. In the initial days of this issue, when there is amendment in the preamble of the Constitution, whether that amendment is permissible, whether preamble can be read with part of the constitution? Court says yes, it is a part of the constitution, can be amended, but can't be amended to the extent that it violates the basic structure. And the preamble and the word mentioned in this preamble all are the part of basic structure, meaning thereby the word used that the sovereign, socialist, secular, democratic republic used in the Constitution of India is part of basic structure doctrine. Legislature can't make any law to declare India can become again the dominion of England, because founding father has something special, something unique at the time of making the Constitution of India. That is the Constituent Assembly. And the power which Constituent Assembly has, that power is gone forever. Now what remain is the amending power. By using Article 368, that the amending power of the Constitution can be replaced as whole by another Constitution, it is also a question. So in the reply of these hyper metaphor, the reply is that the Constituent Assembly has something unique power, that is a Constituent Assembly power, but today we have only the power of amendment. And even the parliament, the sovereignty, the parliament has sovereignty. Even in the preamble we say that we, the people of India, has the sovereignty, but even that the court has power of judicial review to check to the extent that the basic structure of the Constitution cannot be disturbed. It can't be amended. Keswanand Bharti case, we will discuss this case, but what we are trying to understand that how the court use the provision, that you have to understand that constitutional law is related to the law issues relating to the constitution, provision of constitution itself, and other issues relating to criminal law, civil law, evidence law, that are governed with statutory provisions, statutory acts. But in way of interpretation, way of working of law, that the written law in a practical life, and how the judge, we advocate and other stakeholders deal with, is that every provision has to be followed, and at what extent, what will be the limit, which provision would be made for as a safeguards, made for, has to be followed, which would be mandatory, which would be obligatory, all are set of rules are there to interpret them. And therefore when Article 12 says that Indian government, state government, Indian legislature, other local authorities, that all are state, and with the further litigation, Supreme Court has interpreted that the various organizations like universities, municipal corporation, all come into the purview of state. Court says that if the government has some control, if the government has some monetary regulation, if the government finance them, that all institution, companies come within the purview of state, within the definition of state. And state cannot make laws, and laws define in this section 13 that it may be customary law, it may be rules, it may be regulation, it may be ordinance. There is no typical definition. It simply gave example and says if something look like this, come into this genesis, that is state. And if there is abrogation of fundamental rights, Article 32 is unique remedy given as a fundamental right to the citizen, that he may approach Honorable Supreme Court invoking writ jurisdiction under Article 32. And if there is a violation of principle of natural justice, whoever work for executive, or there is executive functions, the principle of natural justice, the concept that everyone should be given opportunity to be heard and no one can be judged in his own cause, these principles should be followed. And therefore if you see that if in your day-to-day business you deal with several institutions, there are very government offices, we as a citizen, you go at several steps you have to be followed, and sometime you have to invoke your writ jurisdiction if there is a violation of any legal right or violation of principle of natural justice, or you have not given up any opportunity of hearing at all, and any adverse, any right that may be penal in nature or abridge your any comfort or any easement rights, you may invoke this jurisdiction against the state. Further, the writ jurisdiction for the legal purposes you may also invoke in a cases of registration of malicious cases against you. At the initial stage when FIR is registered, you may approach Honorable High Court and invoke the jurisdiction of writ under Article 226 of the Constitution of India. So, making this separate lecture on the independence of judiciary, it is necessary to understand how the judiciary check the whether the law which is made is constitutional, whether it is not violative of principle of natural justice. Because suppose that there is an order is passed or some regulation or some advertisement is passed, and that not under the standard which prescribed by several guidelines by the Honorable Supreme Court or a standard procedure adopted by the courts, then it infringes the rights of the citizen, and they approach the court, and who are indulging with this field, they know how much complex all this process is. So the Constitution of India has several key features, and one unique feature is how the judges is appointed in the Indian court. The Honorable High Court and the Honorable Supreme Court, at both level, selection procedure is different. At the Supreme Court level, the collegium that the Chief Justice headed and sit with 4 senior judges of the Honorable Supreme Court and appoint or recommend, we can say, from the list of several recommendations to appoint a particular person as a judge of the Honorable Supreme Court. Same is also done at the level of High Court, that the Chief Justice and another 2 senior judges recommend the name of the advocate practicing before them to the Honorable Supreme Court, and then Supreme Court with consultation of the government appoint the judges of the Honorable High Court. But in the High Court, almost 30% seats are there for our judicial officers who is practiced as a district judge, additional district judge in the service, and with their performance they got elevated to the Honorable High Court. So there is a mixed system in the Honorable High Court for the appointment. We can say a very complex procedure of collegium at the High Court level, and 30% appointment from the higher judicial services, and at the Supreme Court 5 senior judges appoint with the consultation of obvious from the government the judges. At the district level, 2 type of appointment of the judges, one is at magistrate level and one is at higher judicial services. Further, in the salient feature of the Constitution, we have good and services taxes, that is the GST, and earlier for passing the goods and service tax there was amendment passed in the Constitution, and where the state has given consent and abrogate their right to leave the tax, because in earlier segment when VAT was there, tax was imposed by and collected by the state, but here the state has given consent to collect the tax by to the center. It is a vast power which state has surrendered before the center, and the GST law make enforcement in today. So it is also a very unique feature. Further, the concept of reservation is also a feature of the Indian Constitution, and it is a fundamental right.